Welcome to Estate Planning Beyond the Binder.
Hey there, welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trusts and a leading estate planning attorney serving Orange County families for over 25 years. My name is Kevin Rosenquist, and today we're asking a big question. What really happens if you die without an estate plan in California? Brian, welcome.
Thank you, Kevin.
What does it actually mean to die is it intestate or in California?
Intestate.
Intestate. I knew that.
It's basically when some, and this, unfortunately happens far too often, is people pass away with no documents. They don't have a trust, don't have a will, in which case then the government has a plan for you. And unfortunately, the government plan is potentially the most expensive plan, and obviously may or may not reflect what ultimately you want to happen.
Sure.
In California, it's pretty straightforward. If you pass away, your assets, whatever, and again, this is assuming you don't have beneficiaries designated. So like you have a bank account, you designate beneficiaries. That's not intestate. That's the bank. But of course, that person needs to know about the money because the banks aren't going to raise their hand and say they have the money. That person goes and claims whatever's theirs. But assuming you didn't do that, you didn't name beneficiaries and or had a house, and you don't have any a trust or a will, the assets will be divided up per the state, which is it'll first go to your spouse. If you don't have a spouse, it'll go to your children or your grandchildren equally. If you don't have any of those, then it'll go back up. This is called heirs at law. It'll go to your parents, brothers, sisters, nieces, nephews, aunts, uncles, and cousins. So that's kind of the stated plan. And again, as long as somebody's alive at whatever level, whether it be spouse, kids, grandkids, parents, whatever, as soon as somebody's alive at that level, they'll get it. And it'll be split. If there are multiple people at that level, it'll be split equally amongst those people. And so while for some people that may sound fine, at the end of the day, I want the money to go to those people. That's how I'd want it to go anyways. Right. The problem is, we talk about it quite often is it may go to probate. Okay. Because you're gonna have to decide who's in charge of the money at that point, who's in charge of the house, to do whatever they need to do with it. And they're going to have to go to probate. And they're going to have to hire an attorney most likely, and those attorneys are going to charge tens of thousands of dollars to get it through the process, even though we already know the plan. We already know who's getting it. Okay, there is no deviation from that plan for the most part. It's now you're going to be paying tens of thousands of dollars in legal fees, and so that's going to just cost the family a lot of money. And the average probate case in Orange County right now is taking 1 to 2 years to resolve itself, uncontested. Of course, when there is no will or trust, that adds additional costs because there's additional procedures involved that, again, potentially cost your family money.
Now, when you were just talking about if there isn't a home, right? What if there is a home, bank accounts, other assets?
Well, definitely, if there's a home, that'll be the number one issue. That'll be the number one thing that's probated. And one thing, the probate fees are based on the gross value of the house. So you could have $1 million house with an $800,000 mortgage on it, and there's only $200,000 equity, but the fees that are going to be charged are based on the $1 million value of the house, which again is going to run in the $20,000. And so now we're talking, that's a huge percentage of your assets that are going to be subject to the probate costs. What wouldn't be subject to probate, what I was mentioning is if you did have an account, a financial asset, and you did name living beneficiaries, those people get the money. That's not subject to probate unless that beneficiary is under the age 18, which could be your kids. It would go to probate even if they're under 18. And so, again, that would potentially cost your family money. Or even if you have a house and it goes to probate, not only do you have the probate costs, but the selling costs are significantly potentially higher. And not so much the selling costs, but because of the procedures, there's a good chance your house is going to sell for less than it would have if it had to go through probate. Just because the extra procedures involved with probate and selling a house through probate can deter other buyers, and thus you may have less, that your house may sell for less because people don't want to hassle with a house in probate.
What surprises you, or what surprises people the most about the probate process that you'd like to kind of share today?
I mean, I think the cost. And again, for what is typically, in most cases are 95, people think about things going to court. Most probate cases, nothing's happening. Okay. It's a bunch of, it's a complicated proceeding, but there's no argument. This is not, Perry Mason's not getting up there and making arguments and motions and stuff like that.
Yeah. It's not law and order.
It's not law and order. This is 95% of the cases will be completely unopposed. In fact, they'll call 10 cases at once and say, anybody have any objections, questions, whatever. And there's usually silence, and they move on to the next 10 cases.
Mm-hmm.
And so you're spending, there's a lot of money being paid to attorneys for mostly doing paperwork. Because again, yes, we do have the probate cases, and again, those are when the fees are going to be even higher. Where people are arguing and making motions and stuff like that. Objecting to things. Yeah, we have, but that's a relatively small percentage of the probate cases. 95% of the probate cases are completely unopposed. With that being said, even though they're completely unopposed, because the courts aren't working quickly, it is taking 1 to 2 years for uncontested cases to get through the probate process. So the money, while you may be able to do things like sell the house, the money doesn't come out of the trust or out of probate for 1 to 2 years. And that's not likely to speed up. It's not like they're investing more money in judges and making the court system faster. It just keeps getting longer and longer for probate, the process to go through. And so that's why I think that's what people most surprised is in very standard cases, money's going to the kids. It's taking 1 to 2 years. Nobody arguing. The kids aren't fighting. There's no arguments. It's just a 1 to 2 year procedure. And that's probably the biggest surprise for most people beyond and then the thousands of dollars it costs for no arguments.
I've heard from estate planning attorneys that they find that some people out there think that the state will automatically take their property if they don't have a will. Why does that rumor exist?
Because technically, if so, this is what happens, and this happens, it's happened to me. If a bank has assets and no one accesses those assets over a period of time, or somebody dies and nobody comes and claims it, that money will be turned over to the state. Okay. However, the state doesn't just take that money and start spending it. They're holding it for you. That's why there's an unclaimed property website on the Secretary of State where you can go and search to see what assets are maybe held in your name. And I found $1,500 the other day. I had a bank account. I forgot about it. They closed it, and then they had to turn the money over to the state. And the state just waiting there. I just need to file some paperwork, and they'll give me my money back. Same thing with dormant accounts. And this is where people get that call from some random person saying, "Hey, you pay me some money. I found some money for you. If you want it, I can get it for you, or I can help you get it." That's because, again, the state, they don't get it. They just hold it. But because somebody has to hold it, because the banks aren't allowed to hold the money after, if it's been dormant after, I don't know the exact number of years, after X number of years, they're forced to turn it over to the state. And that's where that rumor comes. But they don't, again, the money's recoverable. But again, someone's going to find it.
Right. One of the things we've talked about on this show is conflict amongst family members and stuff. If someone dies without a will, do you feel like that adds conflict? It almost is like kind of takes the conflict out. Not that I'm advocating for it.
In some respect, yes, because now you are going to, and in a handful, there are not many cases, but there are a handful of cases where probate might be a good thing because you have a judge as a referee. And in this case, though, when in this type of situation, there is no, other than proving I was a child, which in the case, as an example, when we do a trust, we specifically eliminate any biological children you didn't know about. Okay, so there's no kids coming out of the paperwork, out of the woodwork to claim their share. We say you had to have a parent-child relationship, which means you had to be aware of them in order for them to get something. In an intestate case, if you're a biological child, you're entitled. If that person died and you're a biological child, it doesn't matter whether they knew about you or not, you're entitled. So that's the outside possibility for conflict. But yes, you're accurate in the sense of, if it's fairly cut and dry, it is what it is. There is no arguing. If they were married, the spouse gets it. If they had kids, the kids get it equally. It doesn't matter how much they liked you better. It doesn't matter they were thinking about not giving one of the kids any of the money. There's no plan. It's going to go equally for better or for worse.
Did you say on average probate takes about 1 to 2 years?
Correct, in Orange County, especially after the pandemic.
Okay, is it a fairly expensive process as well?
Yeah, it's based on the fee, based on the gross value of the estate. Okay, so again, it doesn't net out debts, and the
average. Your point earlier about the $1 million home with $200,000 worth of equity in it. Okay,
correct. So the average fee in Orange County is probably $25,000.
Okay, for
again, not much happening, but again, it can obviously be significantly higher. And then the problem with lower valued cases is you're going to have a hard time finding an attorney to take on the lower valued cases. They want the higher, the attorneys, the easier ones would be the higher value. But again, you want to avoid that. But again, dying intestate, the primary issue is if you own a home or you have bank accounts that have no beneficiaries attached to them.
Does a simple will typically avoid probate, or do you need a more robust plan than that?
So a will by itself, and that's the difference between a trust and a will. A will by itself cannot avoid probate because a will cannot transfer control of assets without going to court. Because actually what's the document that's being probated is the will. Okay, even if you have a valid will, that is what has to be submitted to court in order to grant authority to your named, what we call the executor. They have no authority until a document, the court issues what's called letters testamentary to the executor. And now with that letters testamentary, they now have the authority to deal with bank accounts, deal with the house, whatever assets that are just in your name. But they had to go to court to get that, and that's where they're going to pay all the probate fees. And so having a will is subject to probate. In fact, I've talked about this in past podcasts. The ironic thing is the few times I do a will for somebody, I'm telling them, if you actually do the thing you should do, which is name beneficiaries on your accounts, those accounts have nothing to do with your will at that point. They are outside your will. The only thing that really passes into your will is probably in that case, personal assets. And so that's the difference between a trust and a will. Is a trust allows the transfer control of assets from you to somebody else without them having to go to court. They just file paperwork. But with a will, there is no transfer of control of assets that are just in your name without having to go through the probate process.
Can you talk about how, the online sources, whether it's LegalZoom or any of these others that provide documents and things like that, can those, do you find that often people do that thinking they're avoiding probate and then they're obviously wrong later on?
So usually the issue is not the documents themselves. The issue is the execution after doing the documents. And that's where, as a law firm, we feel a great responsibility to our clients to make sure that everything is done properly. In this case, in order to avoid probate, if you don't own a home, just have financial accounts. Again, just having the will doesn't avoid probate, because if those financial accounts don't have beneficiaries or living beneficiaries or beneficiaries over the age of 18, that is going to probate. Okay. So you can have financial accounts with minor children or no living beneficiaries, and that will potentially go to probate. Two, even if you do a trust with the online source, and you don't properly fund the trust, which we've talked in past podcasts is so critical, and that's where we as a firm try to play a big role with our clients, is to do everything we can within our power to make sure the trust is funded and funded properly. You don't really get that from the online source. They might tell you kind of what to do, but they're not checking in, following up with you as far as, hopefully making sure that's being done or doing the work for you potentially. They may or may not be doing that. And they may be telling you how to go get it done. And then it'll be up to you to go get it done. And so that's where, you want to work with somebody who will help you get those things done, as best they can. We can't do all the work for you, but we can provide you all the support that's needed, all the backup, check-in, accountability as we can to make sure that's getting done. Because again, you can have a trust, but if you don't fund it, the assets still may go to probate.
If someone who may have stumbled upon our podcast may be in a situation where they have yet to start their estate plan, know they need to do it, what is the first step in your mind to getting a good estate plan kicked off?
I just tell people, probably the biggest fallacy that most people have is that getting an estate plan is complicated. It's time consuming in the sense of I got to come up with these big lists of stuff, my accounts, my personal assets and things like that. And that's what stops them from doing it. Right. I just tell people 80 to 90% what I need to know as an estate planning attorney is answers to 3 questions. Who do you love? Who do you trust? And how much do you trust them? Okay. Those are the questions you need to think about. Okay. And to the extent you can answer those 3 questions, that tells me 80 to 90% of what I need to know to do an estate plan for you. As I always tell people, I need names. Okay. That's mostly what I need when we talk about, set up an estate plan. I don't need to know about the assets. I need to know what kind of assets you have so I can tell you what to do with them. Obviously, if you're fortunate enough to have an estate tax issue of more than $14 million, we have other things to talk about. But most of us, we don't have those issues. It's just, who do you love? Who do you trust? And how much you trust them? Those are the questions I need answers to, or that's the discussion we're going to have. And the answers to those questions are going to dictate how we set up the plan. And yes, for some people, that can be a complex situation, especially blended families, which we talked about in other podcasts. But, and I always tell people something's better than nothing. Whatever solution you come up with, whatever people you name may not be perfect. You can change it, but something's better than nothing. And that's the whole point of this particular topic. Dying intestate, that's having nothing. Okay, and you want to have something. And I always encourage my client, whether and at the end of the day, if your budget is for LegalZoom, what have you, so be it. But if you can, you want to hire somebody in an estate planning firm, an attorney who can give you advice. That's the biggest difference in when getting something done. If you're talking to a paralegal or online, they cannot give you legal advice.
Right.
Not allowed to. That's practice law without a license. Okay. You need to, if somebody to give you advice, and, advice, for better words, a podcast is informational. Okay. It's not legal advice. I always tell, when I do workshops and things like that, what I'm telling you today is for educational purposes. We are not giving you legal advice. I cannot give you legal advice until I understand your situation. What are your goals? What are your concerns? And then I can give you advice. Okay. Mm-hmm. That's the value we add as attorneys, is to our authority, the ability of us to give you legal advice given your facts and circumstances, given what you're trying to achieve. Mm-hmm. Obviously, if you pass away without any documents, obviously it was less than no legal advice. It's just whatever it is, and hopefully that'll work out. And some people they're fine with that. But if you care, I always tell people do estate planning because they love somebody. They want to make it easier for somebody. At the end of the day, if you don't care what happens after you, so be it. Now, with that being said, you still might care about what happens if you're alive and incapacitated. So that's right. There's some estate planning need to be done, even if you don't care about anybody else. Hopefully you care about yourself enough. But
good point.
People that intestate, again, it may work out fine, but it will be more of a hassle for who, if you did care about those people that you wanted to make it easier, it will not be easier for them. That's why we do an estate plan, is to make it easier for our loved ones when we're not there.
Absolutely.
And intestate will solve, is the legal process that happens after, if you don't have the docs, but it will be much more complicated. It will be much more costly if you don't have a plan in place.
All right. Well, without an estate plan, you're leaving your family vulnerable to delays. As Brian mentioned, you're doing this because you love somebody. So make sure you keep them out of legal battles and decisions made by the state. So don't wait until it's too late. Visit ocwillsandtrusts.com to get started today. If you're finding our podcast helpful, please be sure to like, subscribe, and leave a review. Brian, great having you here again. Thanks so much for your time.
All right. Thank you, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.